Access to Democracy is made possible by donations from the following organizations. Thomson Reuters, a global company with expertise and insight to unravel complex situations in the areas of law, tax, compliance, government, and media. Their worldwide network of journalists and editors keep customers up to speed on relevant global events. Thomson Reuters, The Answer Company. Crutchfield Dermatology, a full-service treatment center and Medi-Spa in Eagan. Their goal is to help you look good and feel great with beautiful skin. The Minnesota Twins are looking forward to another great season in 2023, led by the return of All-Stars Carlos Correa and Brian Buxton. With the return of numerous players who were injured in 2022 and some new acquisitions, another division crown and a return to the World Series are in their sights. Established in 2007, 45th Parallel Spirits was among the first 50 micro-distilleries in the United States. Based in New Richmond, Wisconsin, all aspects of production occur at our facility. If you're interested in visiting and learning more about the 45th Parallel Distillery, please check our website and plan a visit to tour our facility and taste our spirits. Truestone Financial, with locations in Minnesota and Wisconsin, has proudly served its members since 1939. Truestone engages, educates, and supports its members to ensure they have the tools to empower their financial well-being. Truestone Financial, your neighborhood credit union. Learn more at truestone.org.
And welcome to Access to Democracy. Alan Miller with you, and we have a return guest, although he hasn't been with us since the pandemic when he was on Zoom, but Professor Richard Painter of the University of Minnesota Law School. Now, Professor Painter was the chief ethics lawyer for President George W. Bush. I told him that we were going to talk ethics in the Supreme Court today, and he started hyperventilating. I guess that's a normal reaction from this Supreme Court.
Well, Alan, we unfortunately have a situation where the justices of the court don't understand that the public perceives them to be in the back pocket of billionaires and special interests. Because of some really very simple things the justices could have done to avoid this appearance of impropriety. Things they could not, that they simply wouldn't do. For example, accurately disclosing gifts they received. Furthermore, not going on planes with billionaires and yachts with billionaires for free travel.
Well, there was an empty seat in that plane, so of course somebody has to fill it.
Well, we call that the empty seat theory of judicial ethics. If the billionaire has an empty seat reserved for Supreme Court justices, you might as well just hop on aboard. And the same thing with the Harlan Crow's yacht and all the other ethical lapses of this court. This is very troubling for me. I worked in the Bush White House as the chief White House ethics lawyer with all the president's nominees for Senate confirmation on their financial conflicts of interest and other ethics issues. And that included Chief Justice Roberts and Justice Alito. When they went through the selection process, we made sure that there were no ethics issues in their past with respect to conflicts of interest with cases they had decided that both passed the ethics review with flying colors. At that point, I talked with them both about how to prepare for the Senate confirmation hearing and the types of ethics questions that could come up. And I'm really quite shocked at what has happened here. I'm sure that if Justice Alito had been asked in confirmation, well, if a billionaire would give you a free seat on his plane for a fishing trip to Alaska, what would you do, Judge? And I'm sure he would have told the Senate, well, I would buy a commercial ticket to go fishing like every other American. But once they get on the court, everything seems to change. And this is a very, very tragic situation for the U.S. Supreme Court as an institution. I don't blame it on any one justice. I blame it on the court not being willing to enforce basic ethics standards on its own members.
The Chief Judge Roberts is so conscious of his legacy. He always seems to have been really pointed toward his legacy, and yet now that legacy is certainly tarnished the reputation of the Supreme Court today is at its lowest ebb ever in the eyes of the population. And even Justice Roberts has some questions about his wife's income and the tremendous amount of income where she's getting jobs for lawyers who practice before the court. So is that another issue?
That has been another issue. The spouses of the justices are free to have their own careers and make money as they see fit, with some limitations. And one of them is that income does need to be disclosed. Now, that income of Jane Roberts was disclosed, but disclosed as salary. It's not really salary. It's commission, which means she is paid as a headhunter each time she places a lawyer, usually a senior lawyer, with a law firm, and she gets paid for that by the law firm, and these are law firms that are doing business before the Supreme Court. A commission rests entirely within the discretion of each law firm that she's doing business with. That's a very different situation than a flat salary. It should have been properly disclosed. Preferably, ideally, the wife of the Chief Justice would not be in that type of business, would have used her skills in the legal community to do something else, to work with law firms that do not practice in front of the Supreme Court. There are plenty of things that the wife of the Chief Justice can do that do not involve interfacing with those law firms. I wish she'd chosen a different career. She has a legal right to do what she did, but they did not disclose it properly. That is very troubling, along with the fact that Chief Justice won't look out for what the other justices are doing and making sure they comply with the disclosure rules, which they're not.
And they don't even have, apparently, an ethics regimen that they follow. According to the Chief Justice, he just says that, in effect, we're above it.
And that's the way they feel, that they're above it all. Now, there are certain statutes that apply to them. The Ethics in Government Act of 1978 requires the disclosure of gifts and income, accurate disclosure. Justice Thomas's trips on Harlan Crow's yacht needed to be disclosed. They weren't. Some of his other transactions with Harlan Crow.
What about his, is it his nephew who got a free education? Or his mother who had her house repaired and also lives for free? And we're talking hundreds of thousands of dollars between those two. I don't think either of those was disclosed. They
were not disclosed. They need to be disclosed because both were transactions that involved Justice Thomas himself. Technically, if someone had just given money to the justice's mother, it would have been unsavory, but wouldn't have to be disclosed. But the problem is Justice Thomas himself sold the house of his mother's house to Harlan Crow. That was his transaction, and his mother's still living there. That needed to be disclosed. The nephew
and living there rent-free.
And rent-free. Right. And it's clearly a transaction with Justice Thomas and Harlan Crow needed to be disclosed. The nephew was living with Justice Thomas. Justice Thomas was the guardian, the legal guardian. The nephew made the decision to place him in a private school. And when you are a legal guardian of a child and make a decision to place them in a private school, you are bound by the tuition payment obligation. Harlan Crow relieved him of that obligation. That needed to be disclosed. The trips on the yacht needed to be disclosed. So Justice Thomas has multiple disclosure lapses. A more minor disclosure lapse for Justice Gorsuch, who did not disclose who he sold his Colorado property to, a lawyer who's head of the firm in the District of Columbia. And then also, of course, Justice Alito, who 2 years after he went on the court was off on this fishing expedition in Alaska on the private plane of Paul Singer, the billionaire. The whole thing was set up by Leonard Leo of the Federalist Society.
And Leo of the Federalist Society has had a lot to do with making the selections of people who were presented to Trump as possible judges. Isn't that so?
Oh, yes. Leonard Leo has been involved with selection of justices and confirmation battles for decades. Much more so now than in the past, but he's been very much involved for decades. He was involved during the Bush administration, just nowhere near on the scale that he's been involved recently. According to the New York Times, Leonard Leo is spending around $180 million a year on various battles over the courts. He has raised money from a billionaire who literally gave Leonard Leo his company that Leonard Leo could turn around and sell in a nonprofit. There's enormous amounts of dark money there.
Used for lobbying and lawsuits?
So lobbying, lawsuits, getting involved with the confirmation process, making sure President Biden doesn't get anyone on the Supreme Court or whatever he wants to do. We're talking about enormous amounts of money, almost $200 million a year, massive amounts of money being spent. And this is just by one individual, but he's the same man who set up the fishing trip for Justice Alito with Singer. Paul Singer is on the board of various organizations, including, I believe, the Manhattan Institute, that submit briefs to the United States Supreme Court. These amicus briefs. Senator Whitehouse said in an article.
For the audience, amicus is friend of the court.
Friend of the court, amicus curiae, friend of the court. I suggested that Harlan Crow ought to rename his yacht amicus curiae. It looked very nice right there on the bow of the yacht and on the stern, amicus curiae. That friend of the court. That's what this is all about.
The concept of justice being blindfolded is that when cases come before these people, there shouldn't be any taint to them, and they shouldn't be dealing or self-dealing or double-dealing with people that they have regular contact with. And that's with both Thomas and Alito at the present time. That has been a really big problem this last year.
Well, certainly with these free trips with the billionaires has been a problem. The problem with these organizations, though, that fund, bankroll the confirmation battles and then are funding the amicus briefs. It's not disclosed in the amicus briefs who's paying for those organizations that file them. And yet some of the justices know, and they may know that those are organizations that were critical to their confirmation fight. There's an enormous amount of money being spent on selecting judges, confirming judges, trying to keep other judges off the court if they're not ideologically appropriate in the eyes of the billionaires. And all of this is corrupting the court.
Our present Attorney General probably would have been a really great Supreme Court justice had he not been kept from the court by Mitch McConnell.
Yes, I wrote an op-ed in the New York Times in 2016 saying that I believe that President Bush might very well have chosen someone like Merrick Garland for the Supreme Court if he had had to get the nomination through a Democratic-controlled Senate. And President Obama at the time nominated Merrick Garland when he had to deal with a Republican-controlled Senate. Merrick Garland would have been an excellent choice for any president dealing with the Senate of the opposite political party. He's very much of a centrist. I believe Merrick Garland would have been a fabulous Supreme Court justice. I'm not as thrilled with his performance as a prosecutor.
That makes two of us.
But I think he was a fabulous Court of Appeals judge and would have been a fabulous member of the U.S. Supreme Court. And it's very tragic what happened to him. And Mitch McConnell said, oh, you can't nominate someone for the court in the last year of the presidency. And then, of course, in the last
unless her name is Amy Coney Barrett.
Well, exactly. It was 2 months before President Trump was voted out of office. Mitch McConnell says, well, there's a different set of rules right now.
And it's not the first time McConnell has lived by a different set of rules, but the country is less for it, and the Supreme Court certainly is less for it. There's a story that I read recently that Justice Kagan was offered, I think, a dinner, and she turned it down. Something very, very minuscule that she turned down simply because she said, no, I don't want to have any shred of impropriety pointed toward me. And that just shows the difference between the caliber of these justices.
Some of them are being a lot more careful than others. I believe there's a serious problem with the court. I am disappointed, I will say, that with all 9, because they signed a memo for Chief Justice Roberts basically saying that the court was in compliance with the ethics rules. So Justice Kagan, I believe, may very well be in compliance with the ethics rules, but we need this court, the entire court, to be in compliance. And unfortunately, Chief Justice Roberts took this memo signed by all 9 and sent it up to the Hill and told Senator Durbin, the chairman of the Senate Judiciary Committee, look, we're in full compliance and I can't come and testify in front of the committee. He'd been invited to testify in front of the committee and talk about these issues. He should.
It gives the impression that he feels that he's above it.
He does not want to testify. He cites the independence of the judiciary and the separation of powers. But the way separation of powers works in the United States, according to our Constitution, is we have checks and balances. The Supreme Court of the United States can strike down laws passed by Congress. Sometimes they do in a way that I think is wrong. For example, the campaign finance law struck down at Citizens United. But the Supreme Court has that power. They are a check on Congress, a check on the presidency. By the same notion, though, that Congress has some ability to check the Supreme Court. They do set the budget for the Supreme Court, the salaries of the justices, and furthermore, if there are ethics concerns with the Supreme Court.
Don't they have the power to pass a law on ethics that would be binding on the Supreme Court?
Well, absolutely, and indeed they already have. The Ethics in Government Act of 1978 required the disclosures that Justice Thomas did not make. And that Justice Alito did not make, and some of the other justices made in a deficient manner. They're bound by the Ethics in Government Act of 1978. They're also bound by the recusal rules in 28 United States Code 455 that requires a judge or justice to recuse from a case in which their impartiality might reasonably be questioned. So the example would be, for example, hypothetically, if a justice were to have a spouse who were involved with an attempt to overturn an election, and then maybe an insurrection that ensued therefrom, that the justice would recuse. A basic rule that if the justice's spouse is an insurrectionist, you recuse from all insurrection cases.
You would think so.
Oh, but it didn't happen in Trump.
It didn't happen with Justice Thomas.
Not with Justice Thomas. No.
His wife was actually requesting that the election be overturned. There's documentation to that effect, and he has refused to recuse himself from any case, as far as I'm aware.
So far, that is the case, and the January 6th Committee of the House of Representatives subpoenaed the White House communications on January 6, 2021. President Trump, former President Trump, filed a case in the courts to try to block the subpoena, Trump versus Thompson. And the Supreme Court of the United States heard Trump versus Thompson, decided that Trump had no power to assert executive privilege over White House emails when he was no longer president. One justice dissented, and that was Justice Thomas, and he said that
that's right. It was 8-1,
and that he said that Donald Trump's request for a stay of the subpoena should be granted. Those emails may very well include emails from Jenny Thomas to White House staff on January 6th of 2021.
And we may yet find that out.
Yes.
Now, have you ever had occasion to talk to former President Bush about the Supreme Court, and get his opinion of what's going on?
No, I have not. I think the presidents, particularly President Bush, has wanted to, once the presidency is over, stay out of commenting on his successors. Or on the other branches of government, with very, very rare exception. I think that it's well known that the Bush family was not happy at all with a lot of things that happened in the Trump years. But former President Bush has been very reticent to jump into the fray as a former president and comment on any of this.
I think Senator McCain must be turning over in his grave also with some of the things that have been going on, because he would have been a voice for moderation in so many respects. And he also obviously had his lapdog, Lindsey Graham, who's now become the lapdog of Trump, unfortunately.
Yeah, Lindsey Graham has definitely decided he's going to say whatever's going to appeal to the base of the far right base in the Republican Party. This is very sad. I was with the Republican Party as a moderate for 30 years. I left the Republican Party in 2018 because of this.
As so many did.
Absolutely, and I've talked to many former Republicans, including Arnie Carlson, former governor of Minnesota, about what's happened to our party, and it's tragic. We need to have two parties in this state and in the country.
Well, it's so essential to have two parties for checks and balances, just as you said. And when I was active in politics, and I've told this story before, back on Long Island, I was active as a Democratic official. We got along great, not like today's partisan divide with the Republicans. They were friends of mine. We broke bread together. The Republican leader of Nassau County showed up and gave lovely gifts and shared my twins' bar mitzvah. I mean, things like that. That seems to be gone now. It's this really animosity that's raging here. Anything that Biden does, they automatically, the Republicans, oppose. And yet he's had a interesting success in so many areas so far.
It's become a lot more partisan, and part of this is that the parties have changed. The conservative Democrats aren't around anymore. The far-right Democrats, particularly in the South, have switched over to being Republicans.
Right.
The liberal, moderate Republicans are gone. And back in the old days in New York, a liberal Republican was someone like Mayor John Lindsay, a moderate Republican, someone
Jacob Javits.
Jacob Javits, of course, a moderate. Governor Rockefeller, a moderate. There were many, there was a wide range in the Republican Party. And then people, thought the Republican Party was too liberal and went out and formed the Conservative Party. I think that was Jim Buckley and others. And, but there was a range also in the Democratic Party. What we see now is an ideological polarization where, at least on the Republican side, the extreme right really feels they rule the roost. I've had my qualms with the far left in the Democratic Party, but I don't see that situation at this point in the Democratic Party. I think the centrists still have some substantial amount of power. But this polarization of the political parties is very unfortunate in the United States, and it's going to lead to a breakdown of civil dialogue over important issues.
We've seen a breakdown really in so much, starting with January 6th and the repercussions from that, with more than 1,000 people who have been arrested and several hundred who are in jail. But I wanted to ask you about one more thing. There's been a lot of talk about expanding the Supreme Court, putting on additional justices to balance the court, putting in a 16-year limitation on time in office. What do you think of that?
Well, when Chief Justice Roberts visited the University of Minnesota Law School a number of years ago and was meeting with the faculty, and he gave us a speech, and then he took our questions, I asked him what he thought of the Judicial Procedures Reform Bill of 1938. That's where President Franklin Roosevelt had recommended and actually urged Congress, proposed to Congress that they expand the number of justices because a far-right Supreme Court was striking down New Deal legislation. Ultimately, they didn't do that because one of the Justice Roberts, by the way, changed his vote to accommodate the president. So this idea has been floated before. It's clearly constitutional. The number 9 is not in the Constitution.
Well, we've had 6, we've had 7, yes. We've had 10.
Congress gets to decide. You'd have to have a bill passed through the House of Representatives and the Senate, signed by the president, and that could expand the size of the Supreme Court. It might very well be a good idea to have 11, 13 justices, have as many justices as we have circuits in the United States. I mean, there are different approaches to this, but we're not going to get that through now. There's not going to get through the House of Representatives for sure.
Not this House of Representatives, no. But we do have the 24 election coming up, and I asked the question because I had that in my mind.
Yes, and that could very well, and that would be constitutional. I mean, if the founders had wanted the number to be 9, they would have put 9 on the Constitution. And I'm one of these people who believes that we should. I'm not an originalist in the sense that we have to go back and figure out what all the founders meant inside their head. They all had different opinions. But when they put it down in writing, I think they got it right on a lot of questions, including the balance of power between the presidency, the Congress, and the courts. It is very clear in the Constitution that the number of judges and justices can be fixed by Congress pursuant to statute signed by the president, and that we could do that, and that might change the composition of the court. Might have a court that looks more like America, and that's almost somewhat more deferential. This has been a very activist court. I mean, there's a court that is striking down laws right and left. They strike down campaign finance. They tell a public university that you can't use affirmative action to make up for past discrimination. I mean, in North Carolina, of all places. You know, I think we don't need as many activist judges and justices.
And yet universities use affirmative action, no matter what they call it, all the time. And really, it's what lends itself to a better really scholastic, you know, picture of things.
Well, that was the view of the Nixon administration, and they introduced affirmative action. I disagree with Richard Nixon on a lot of things, but I think they got it right that was a good strategy. Certainly in places like North Carolina, where a university is still struggling to attract African-American students, and yet an activist Supreme Court tells them they can't do it.
We have got a lot more to talk about, and believe it or not, we just about run through our time right now. So I hope you'll come back in the near future where we can really discuss this further and maybe go into some of the cases that really have turned heads as a result of this Supreme Court of this term, which just concluded. We've been talking with Professor Richard Painter of the University of Minnesota Law School, former ethics chief for President Bush, and I thank you very much.
Thank you very much, Alan.
Thank you.